This is America's Morning News, where the nation's news breaks on this 20th day of October. I'm Matt Ray. We start with breaking news out of Texas, clarifying an earlier ruling. A federal judge in Fort Worth said this week that his injunction that barred the Obama administration from enforcing its school directive on transgender bathrooms applies to every state in the nation and not just Texas. So what does this mean? What's likely to happen next on the president's directive on transgender bathrooms? Let's bring in Byron Henry, a regular guest here on America's Morning News. He's a constitutional scholar and also an appellate attorney. The website is solidcounsel.com. Byron, thank you for joining us on this Thursday morning.
Great to be with you, Matt.
Let's clear this up for us if you can here. The judge, Reed O'Connor, clarified that the preliminary injunction applied only to the federal directive that schools allow transgender students to use the restroom and locker room that conforms with their gender identity. It didn't otherwise affect the government's, quote, core missions to combat discrimination based on race, national origin, or disability. Explain that to us. What does the judge mean by that?
Well, as you know, the directive stems from the basically rewriting of Title VII by the President Obama administration and the Justice Department based on the education directive that said that the word sex in Title VII includes gender identity as well as gender as we've always understood it going back to when the bill was passed. And so what the judge is saying there is you can still enforce the general rule that we've all accepted with respect to enforcing discrimination based on gender. You just can't transplant the word gender for gender identity and force schools to allow those persons that are anatomically males and females versus the way they identify to use intimate facilities, as the judge calls it, and bathrooms. Intimate facilities meaning all the facilities such as locker rooms where people change and are exposed, physically to others in the restroom. So basically the judge is letting them know that you can continue to enforce the law with respect to gender or sex discrimination. You just can't enforce it with respect to gender identity until a final order comes down in the case.
And so this applies nationwide. So, I mean, the school districts are free to reject this nationwide. Is that correct?
That's true. A couple things about that. If you remember, the same thing occurred when the immigration executive orders came down, and the judge in South Texas, Judge Hainan, issued an injunction against enforcing the executive directives with respect to immigration, and the judge in that case made clear it was an injunction against the federal government from enforcing it, which means it applies wherever the federal government would attempt to enforce it. But also the judge made clear that if a state or independent school district wants to follow the directive, it doesn't prevent a state from voluntarily complying with the directive. It just prevents the federal government from forcing the new interpretation of Title VII onto a state or school district until the court finally rules in the case.
So where do attorneys for the federal government, where do they go from here?
Well, they can appeal the case to the Fifth Circuit. Preliminary injunctions such as this are appealable immediately to the Fifth Circuit, and that's what happened in the immigration case. And as you know, that went all the way up to the Supreme Court and was affirmed by an equally divided 4-4 court. They could do that here as well. But remember one thing: Virginia had this same case. A Virginia Court of Appeals has already ruled on this issue in a very close case, and the Supreme Court of the United States issued a stay in that case in the Fourth Circuit, where they ruled in favor of the federal government. So the Supreme Court has already weighed in, at least for now, and issued a stay of the ruling in the Fourth Circuit. So the federal government already has a case proceeding up the chain that's ahead of this one with respect to this issue. So whether or not they appeal this specific issue or just wait for that case remains to be seen.
Our guest is constitutional scholar and appellate attorney Byron Henry, federal judge clarifying his injunction on school rules for transgender students in bathrooms and locker rooms applies to all 50 states. I'm assuming, Byron, and correct me if I'm wrong, I'm assuming this is a message to the president and going through Congress rather than a directive, I guess, if you will.
That's true, and this is just one of many cases in which regulatory agencies or administrative agencies, in this case the Department of Education, we had this occur, of course, with immigration. It's also occurred in the overtime rules. It also happened with, as you know, with Obamacare, with the president's executive agent, the executive branch or an administrative agency basically rewriting rules, which courts have said in numerous cases now were actually a change in law that required Congress's approval and not just a change in the rules by an administrative agency. So it seems to be, at least, it seems to be a pattern of conduct that when the president cannot go through Congress to get a law changed, the circumvention of Congress through administrative agencies it seems to be a pattern of conduct, because this is the third or fourth case now where a judge, either a court of appeals or a district judge, has basically enjoined a change in the law through administrative rulemaking process, and this is just another example of that.
We're less than 3 weeks out from Election Day. Does the federal government appeal this decision, or where does it go as far as the timeline?
Well, as I said before, there's already a case on this very issue that's ahead of schedule, ahead of the Texas case, but in that case, the federal government actually won, and the Supreme Court stayed the decision. So if they want to enforce this directive anywhere else in the United States until a final ruling in the case, they're going to have to appeal this. It's kind of ironic that the federal government said this directive is not mandatory and it's not final agency action, but then they come back and ask the federal judge if it can be enforced nationwide or just in Texas, which leads you to believe that, of course, it was an agency directive, because otherwise it wouldn't be enforceable. You wouldn't need to ask permission to enforce it if it's just a letter advising the districts of the Department of Education's general position on something. So certainly there is teeth in that directive. If anyone remembers what it said, it's very, very direct and straightforward. And for now, they are not going to be able to advance that or that goal until they either appeal it or get another court to weigh in.
Good stuff, Byron. We appreciate it as always. Thank you so much.
My pleasure.